Hey everybody, we're talking about legal aid is a scam today. Now, whether you want to call it legal aid or public pretender or public defender or whatever you want to call it, it's all a scam. And we're going to go into why it's a scam. First of all, who are attorneys? Well, between 75 to 90% of all lawyers are either incompetent, dishonest, or both. And that's a quote by Earl Warren, who's a former Chief Justice of the U.S. Supreme Court. If you remember, he was in charge of the Warren Commission when Kennedy was assassinated. And so it's been a few years, but that's a quote by him. This is from Book 7 of Corpus Juris Secundum, Section 4 on attorneys. Says he is, however, in a sense, an officer of the state with an obligation to the court. Okay? And it goes on. It says his first duty is to the courts and to the public, not to the client. And whenever his duties to his client conflict with those as an officer of the court in the administration of justice, the former must yield to the latter. So his first duty is to the court. Okay, and if it's a kangaroo court, which it always is, then you see what's going on here. Okay, it gets better. Clients are also called wards of the court. So when you hire an attorney, we're going to get into some more stuff here. A ward of the court. Infants and persons of unsound mind. Okay, their rights must be guarded jealously. Yeah, right. I'll bet they're going to guard your rights. Black's Law Dictionary, 4th edition. A ward of the court is an imbecile. A ward of the court is not competent. Everything is about competence and incompetence. That's why they are representing you, because you're not competent to make decisions for yourself. Therefore, the attorney is going to make decisions for you. There is no such thing as an incompetent sovereign. If you want to be the king, then you cannot hire a lawyer. Do you know who you are? In propria persona, in one's own proper person. It is a rule in pleading that pleas to the jurisdiction of the court must be pled in propria persona, because if pleaded by an attorney, they admit the jurisdiction. As an attorney is an officer of the court, he is presumed to have pled after having obtained leave which admits the jurisdiction. Okay, so if you have an attorney, you just gave him jurisdiction. The practice of law cannot be licensed by any state. The practice of law is an occupation of common right. Okay, so you don't need an attorney, and anybody can help you as counsel. Okay, these bar member Satanists want to keep anybody out of there, but and it's not going to be easy. These Satanists, they're nothing but a bunch of Satanists. And get a load of this. A retainer is a sum of money paid by a client to secure an attorney's availability to work for a client. The fee paid is considered earned at the time of payment because the attorney is entitled to the money, regardless of whether he actually performs any services for the client, and the funds shall not be paid into the attorney's trust account. So there you go. Okay, once you paid him, you just sold your soul. You sold your money. You just gave it away because now he can do whatever he feels like doing, and he doesn't have to do anything. Inns of court. These are certain private unincorporated associations in the nature of collegiate houses located in London and invested with the exclusive privilege of calling men to the bar. That's Black's Law Dictionary, 5th edition. There is an American Inns of Court Foundation. Every state has a local courts chapter. This is the American Inns of Court website. And it says here, if you look, it says it's located in Alexandria, Virginia. And this is their website. The city of London is downtown. London is walled in approximately 1 to 2 square miles. The Imperial Parliament buildings are located in the city of London. The city of London was never conquered by William the Conqueror. The city of London has several gates. One of the gates is called Temple Bar. The only true law schools in the world are in the city of London. They teach 800 years of jury trial decisions. That's where real law comes from, is jury trial decisions. We, the people, make the law. Inns of Court is one of those law schools. City of London is foreign territory to the rest of England. During the convening of the Imperial Parliament, the Queen gives the throne speech. The Queen goes to Temple Bar and requests permission to enter the foreign territory. The Lord Mayor grants permission. The Queen then walks 2 steps behind the Lord Mayor with her head bowed while she's in the City of London. And they have to leave a ransom. The City of London, they have to leave a ransom because they don't have to give her up. This is the concessions to the Pope. We will establish perpetual obligation, a concession which will establish that from the proper and special revenues of our aforesaid kingdoms, for all service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling. Okay, this is tribute that King John pledged to the Vatican. Okay, this is taken from concessions to of England to the Pope, 1213. After the concessions of England to the Pope, 1213 was signed, King John had to make money to pay his tribute. King John imposed martial law rule and started to do things to raise money to pay his tribute. It took only 2 years for the people to figure out what was happening, and the Magna Carta was the result. This is a Quebec court case. Perlman versus Piché and Attorney General of Canada, reference habeas corpus. It's found at 4 Dominion Law Reports, page 147. The Magna Carta is not a unilateral act emanating solely from the spontaneous will of the king, as the charters of the predecessors of John. Neither is it a treaty, for we cannot say it was concluded between 2 legitimate and independent sovereignties, nor between 2 nations, nor is it a law. The barons do not appear in it as subjects, for they are freed from their promise of fidelity, and the king, brought captive, placed before them, submitted to the conditions which the conquerors imposed upon him. Magna Carta is therefore a contract, but resembles a treaty concluded between 2 nations, in that one of the parties, in virtue of the law of war, can impose its will upon the other. In other words, think about it. They stuck a sword to his throat, and they said, "Here, king, we want you to sign this." This is, and the reason I'm going through this is I'm showing where the bar members, okay, these Satanists are coming from, okay? This is Yale Law School, the Avalon Project. It's talking about the definitive treaty of peace of 1783. And it says, let's see if I got this in, nope, okay. It having pleased the divine providence to dispose the hearts, the most serene, most potent, King George III, by the grace of God, King of Great Britain, France, and Ireland. Okay, so he was King of France and England at the time. And it's interesting to note that France financed the War of Independence. So if you think about it, King George financed both sides of the War of Independence. And if you read on, it says, he was Arch-Treasurer and Prince-Elector of the Holy Roman Empire and of the United States of America. Okay, so he is Arch-Treasurer and Prince-Elector of the United States of America. So Queen Elizabeth is his descendant. King George was King of France and England. He financed both sides of the War of Independence. United States owed France 18 million livres at the end of the war. Arch-Treasurer and Prince-Elector of the Holy Roman Empire and the United States of America. Queen Elizabeth is now Arch-Treasurer and Prince-Elector of the Holy Roman Empire and the United States of America. The reason that terminology is in this treaty is because it's relevant. It is showing his authority to make the treaty. He perjured his oath. He breached the trust. He's operating in his private capacity, and he used the Vatican's money to finance it. Okay, that's what you have to understand, is he used the Vatican's money to finance the War of Independence. An officer who acts in violation of the Constitution ceases to represent the government. But when a long train, this is taken from the Declaration of Independence, okay? This is what the Vatican, it's all over the place, okay? This is what the Vatican orchestrated. But when a long train of abuses and usurpations pursuing invariably the same object evinces a design to reduce them under utter despotism, it is their right, it is their duty to throw off such government. That's in the Declaration of Independence. And if you think about it, the Declaration of Independence is a list of grievances, okay? And so these are some of the grievances. He is affected to render the military independent of and superior to the civil power. He is combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. Okay, this is all talking about martial law and color of law, for imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury. Well, gee, all of that stuff is going on today. For abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government. Gee, that sounds like a military dictatorship. And enlarging its boundaries so as to render it at once an example and an instrument for introducing the same absolute rule into these colonies. Gee, that sounds like military dictatorship. He has abdicated government here by declaring us out of his protection and waging war against us. Okay? Gee, that sounds like military dictatorship. That's exactly what's going on today, for protecting them by a mock trial. And so that's a show trial, a kangaroo court. That's exactly what's going on today, and that's all these bar members from the City of London that are owned and operated by the Vatican. That's where it's coming from. This is taken from the Causes and Necessities of Taking Up Arms, 1775. Statutes have been passed declaring the courts of admiralty and vice admiralty far beyond their limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish and order the use and exercise of law martial. Okay? And that's exactly what's going on today. They've superseded common law and there's martial law everywhere. And, you know, get a load of this, eh? This is George III, Chapter 12, 1778, okay? 2 years after the Declaration of Independence signed, they passed this act in England. And it goes, whereas taxation by the Parliament of Great Britain for the purpose of raising a revenue in His Majesty's colonies, provinces, plantations, and North America has been found by experience to occasion great uneasiness and disorders. Well, no joke, Batman, that from and after the passing of this act, the King and Parliament of Great Britain will not impose any duty, tax, or assessment whatever payable in any of the colonies, provinces, or plantations in North America or the West Indies, except only such duties as it may be expedient to impose for the regulation of commerce. So they knew exactly what they were doing. It's all orchestrated by the Vatican and the Jesuits, and it was planned and orchestrated from the beginning. The Vatican created the slave trade. The Vatican orchestrated the War of Independence. The Vatican orchestrated the War of 1812 to facilitate the disappearance of the true Article 13 Amendment because they wanted their satanic Jesuit bar members to infiltrate America and seize control of the government. And that's exactly what's happened. Watch my bar members videos 1, 2, and 3. They've orchestrated the Federal Reserve. They've orchestrated World War I, World War II, and then now they're in the process of another satanic blood sacrifice called World War III. They orchestrated the Civil War in America to convert citizenship into opposite of what the Founding Fathers intended. This is U.S. versus Rhodes. The amendment reversed and annulled the original policy of the Constitution. And in Colgate versus Harvey, it says, and while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. And so they turned citizenship into the opposite of what the Founding Fathers intended. And the bar members have facilitated the bankruptcy. This is the bankruptcy right here. It's March 9th, 1933. The United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the president may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And this is taken from the U.S. Senate Report number 93-549 dated November 19, 1973. So you think anything's changed? And get a load of this. This is the U.S. Congressional Record, March 17, 1993, volume 33. It's an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress in session, June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolved the sovereign authority of the United States and the official capacities of all United States governmental officers, and departments, and is further evidence that the United States federal government exists today in name only. Okay, that was Congressional Record 1993. And so they're saying March 9th, 1933, the government was declared bankrupt, and on that same day, the government went into a state of declared national emergency, and it's been there ever since. And Canada's the same way, okay? Every country's the same. They put them into bankruptcy and put it under emergency rule. This is a instruction card for a SIN number in Canada, where it says that you have to make a check payable to the Receiver General for Canada, which is a receiver in bankruptcy. When any corporation goes bankrupt, the creditors become the owners, and it is a coup d'etat for the government, except these Satanist bar members don't bother to tell you that fact. So, the number one reason that they want to assault you with their liar is because it gives them jurisdiction. Okay, and this is, again, we quoted this earlier, in proprietary persona, in one's own proper person, is a rule in pleading that pleas to the jurisdiction of the court must be pled in proprietary persona. Because they're pleaded by an attorney, they admit the jurisdiction as an attorney is an officer of the court. He is presumed to plead after having obtained leave, which admits the jurisdiction. And so, again, the number one reason why they want to assault you with one of their liars is because it gives them jurisdiction. Jurisdiction is everything. Jurisdiction can be challenged at any time, and jurisdiction, once challenged, cannot be assumed and must be decided. Defense of lack of jurisdiction over subject matter may be raised at any time, even on appeal. However late this objection to jurisdiction has been made, he may be made in any cause in an inferior or appellate court of the United States. It must be considered and decided before any court can move one step further in the cause, as any movement is necessarily the exercise of jurisdiction. And that's U.S. Supreme Court. Once challenged, jurisdiction cannot be assumed. It must be proved to exist. There is no discretion to ignore that lack of jurisdiction. Where jurisdiction is contested, the burden of establishing it rests upon the plaintiff. The burden of proving jurisdiction rests upon the party asserting it. The court must prove on the record all jurisdictional facts related to the jurisdiction asserted. So, they want to assault you. They want to get you in their jurisdiction. That's why they want to assault you with one of their liars. The next reason they want to assault you with one of their liars is so they can sell you into slavery. That's exactly why. They cannot, if you don't have a liar, they cannot put you in their jail. The controlling rule is that absent a knowing and intelligent waiver, no person may be imprisoned for any offense unless he's represented by counsel at his trial. When the trial of a misdemeanor starts, that no imprisonment may be imposed, even though local law permits it, unless the accused is represented by counsel. The third reason they want you to have one of their liars is because the liar won't object to the hearsay evidence or the testifying by the prosecutor or the prosecutorial misconduct or the fact that the so-called judge is actually a clerk masquerading as a judge. They need you to submit hearsay evidence or it's not admissible. And again, they go ahead and proceed anyways with all this hearsay evidence because the liar won't object. The liar won't stop you from admitting it. He'll let you go ahead. He'll make sure that it all gets in there. And think of all this hearsay evidence. It's all hearsay. A picture is hearsay. A name is hearsay. An address is hearsay. A date of birth is hearsay. Anything in a computer system is hearsay. A social security number is hearsay. A copy of anything's hearsay. A government-issued identification is hearsay. A vehicle registration is hearsay. An insurance card is hearsay. That's why they need to represent you to present the hearsay evidence. An image is a fraud. There's no witnesses. A computer entry is a fraud. There's no witnesses. It's a liar testifying, okay? When their prosecutor testifies, statements of counsel and brief or argument are not facts before the court and are therefore insufficient for a motion to dismiss or for summary judgment. So they won't object to any of that because that way they can railroad you. Some examples of prosecutorial misconduct: asserting facts not in evidence, introducing inadmissible evidence, commenting on defendant's failure to testify, expressing personal opinions, inflammatory comments, withholding evidence favorable to the defense. If you or your liar does not object, you cannot bring it up on appeal, which is why they want to assault you with their bought and paid for liar. You ask the code enforcer examples of more prosecutorial misconduct. Say you're asking the code enforcer under oath on the stand, and the prosecutor stands up and testifies. And maybe we should, so then the answer is maybe we should get the prosecutor over here since he knows all about this matter. The prosecutor says his view of what happens. He's testifying, okay? They do it all the time. When acting to enforce a statute or subsequent amendments to the present date, the judge of a municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely as an extension, as an agent for the involved agency, but only in a ministerial capacity and not in a discretionary capacity. They're bought and paid for clerks masquerading as judge. It's a show trial. It's a kangaroo court. It's the accepted rule, not only in state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes as a ministerial clerk for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. A clerk masquerading as a judge is not competent to do anything judicial like issue warrants or orders. A clerk masquerading as a judge is operating in his private capacity and has no immunity. That bar member Satanist is not going to tell you that either, is he? Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Okay, they don't have, if they issue an order, it's a nullity, it's a fraud. If they do anything, it's a fraud and a nullity. They want to assault you with their liar because it makes business for their Vatican handlers. All governments are owned and operated by the Vatican. All courts are a satanic religious ceremony, and it helps set up the next bankruptcy. They drag you into their kangaroo court, and the clerk masquerading as a judge forges your signature onto their satanic contract to fabricate evidence of a debt. Then they issue a capias to the Satanist order followers to further assault you, kidnap you, and falsely imprison you. All of this makes business for their whores selling their just us in the Court of Appeals. The only thing you can do is go after them for ineffective assistance of counsel and hope that you get, and so they can put on another show trial. And some examples of ineffective assistance of counsel is failure to object to testifying by the prosecutor, failure to object to inadmissible evidence, failure to object to inflammatory statements, failure to object to prosecutor expressing opinions. All of this makes business for their bar member whores. They assault you and fabricate some trumped up vicious charges. Then they give you a public pretender. The public pretender fails to object to the hearsay evidence. The public pretender fails to object to the testifying. Public pretender fails to object to the prosecutorial misconduct. And then they call it a fair trial. By accepting the public pretender, you're giving the court jurisdiction. When the public pretender fails to object to the hearsay evidence and the testifying by the prosecutor and the prosecutorial misconduct, there are no appealable issues for the Court of Appeals. If it's not on the record, the Court of Appeals cannot see it. Then they make work for their liars at taxpayer expense, and the public pretender will probably get promoted to the bench. You have a whore on the bench. Is there any wonder why Christ had such complete and utter contempt for the attorneys of his day? These are Baal priests, and in the old days, they used to put them to death. Okay? And this is 1 Samuel 18:40. And Elijah saying unto them, take the prophets of Baal, and let not one of them escape. And they took them, and Elijah brought them down to the brook Kishon, and slew them there. They killed them all. And these Baal priests, they need to be put to death. Okay, the end justifies the mean. It's satanic. Woe unto them that call evil good and good evil, and put darkness for light and light for darkness. And this is what they're doing, is they're selling you into slavery. If a man be found stealing any of his brethren of the children of Israel, and make merchandise of him or selleth him, then that thief shall die. And thou shalt put evil away from among you. If we don't put evil away from among us, we're going to be held accountable. And through covetousness shall they with feigned words make merchandise of you, whose judgment now of a long time lingereth not, and their damnation slumbereth not. By which he also went and preached to the spirits in prison. Okay, that's hell. Okay, spirit prison. And it shall come to pass in that day that the Lord shall punish the host of the high ones that are on high, and the kings of the earth upon the earth, and they shall be gathered together as prisoners are gathered in the pit. And they shall be shut up in the prison, and after many days shall they be visited. So all these Satanists, all these Baal priests, they're all going to hell. But we need to help them along with that, people. It behooves every man who values liberty of conscience for himself to resist invasions of it in the case of others, or their case may, by change of circumstance, become his own. If ye love wealth better than liberty, the tranquility of servitude better than the animating contest of freedom, go home from us in peace. We ask not your counsel or arms. Crouch down and lick the hands which feed you. May your chains set lightly upon you, and may our posterity forget that you were ever our countrymen. When shall it be said in any country of the world, my poor are happy, neither ignorance or distress is to be found among them. My jails are empty of prisoners, my streets of beggars, the aged are not in want, the taxes are not oppressive. The rational world is my friend, because I am a friend of its happiness. When these things can be said, then may that country boast of its constitution and government. Well, we have nothing to boast of here. The streets are full of bag people and beggars. The aged are in want. Most people are such brain dead, ignorant people that they don't have a clue. And the jails are full of prisoners. We have nothing to be proud of. We have a gang of criminals that have taken over the government. But if the watchmen see the sword come, and blow not the trumpet, and the people be not warned, if the sword come and take away any person from among them, he is taken away in his iniquity, but his blood will I require at the watchman's hands. And so the reason I'm doing this is to make sure I'm blameless on Judgment Day, because and I hope everybody watching this becomes blameless, but there's going to be a Judgment Day, and these people are, I'm going to be in on it. I know it. Either you're part of the problem or you're part of the solution. You are now a watchman. Circulate this video far and wide. Other videos: Bankster Thieves 1, 2, and 3, the Churchianity series, bankrupt corporate so-called governments, bar members 1, 2, and 3 actually, Unidroit, martial laws here, quasi-contracts in Roman civil law, de facto courts, all courts, ecclesiastical courts, DC courts in Texas, and jurisdiction. Copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. I have YouTube videos that are videos of private information shares that show these and other court citations that are available for a donation. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept IOUs, Federal Reserve notes, PayPal, gifts, checks, money orders, etc. Send me an email for particulars. That last paragraph is for the Satanist revenue officers operating in their private capacity that seem to think that I'm accepting some privilege or benefit. They can put their privileges and benefits up their rectal orifice. I prefer gold or silver coin. If you find this useful, then you need to pay it forward. If you don't know what pay it forward means, then watch the movie. It's available for rent. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo. My YouTube profile is Sovereign Living. I have a Facebook community page called Sovereignty International and a private group called Sovereignty International. I have a Yahoo private group and a Google private group. Both of them are called Administrating Your Public Servants. I appreciate you taking the time to watch this. I hope you get something out of it. Do not ever, ever, ever hire a lawyer. Do not ever, ever, ever accept one of their public pretenders. You're selling yourself down the river as if you do, because they're going to sell you into slavery. They do it all the time. They're not interested in doing anything for you, and they're just interested in stealing your money, okay, or your property. And thanks for watching, and I hope you have a real nice day.